Mr. Rosellini, do you think that in every instance in which a legal standard, no matter how, no matter the degree of concreteness of the legal standard is applied to a set of facts, that the ultimate determination is a legal question?
No, Justice Alito, we don't think that. We think that under this particular statute, when that inquiry looks a lot like an admission eligibility decision or an asylum entitlement decision, but isn't one of those like we have here, that's a situation where, yes, the application of law to fact would be de novo.
My question is similar to Justice Kagan. So the definition of persecution that was applied by the IJ here is, based on First Circuit precedent, is that it must add up to more than ordinary harassment, mistreatment, or suffering. You may have a set of historical facts that are undisputed, but determining whether they add up, whether the totality of those facts satisfies that standard, sure looks to me like primarily a factual question. Why is it not?
Because when courts make that decision, they are building out a body of decisional law that guides future cases. If you look at the First Circuit's decision in this case, the IJ's decision in this case, they are analogizing to cases that came before.
But that would be true in a vast majority of situations. Do you think the determination of whether of negligence is a legal standard?
No, Your Honor, we would agree that negligence would be something that's reviewed deferentially, but I think there's actually a helpful—
But every case where negligence is found or not found could be said to build out a body of precedent about whether negligence was shown. Why isn't this similar to that?
Because I think negligence, number one, the inquiry there is basically what should a person have done given the circumstances. The light was red, should they have braked or accelerated? People have an ordinary sense of that. I think the negligence example is a helpful one because you can contrast it with the duty of care inquiry, which, and as you know, as this court well knows, duty is traditionally for the judge, negligence is for the jury. And in the duty context, you do have to get immersed into the record to establish whether there was a duty of care. But if you ask someone on the street, hey, was there a duty of care in this circumstance or that, they're not going to be able to answer that as readily. And courts build out, again, a host of legal principles for different kinds of situations in the duty of care context. And that's what happens when courts apply the persecution standard. They're taking a term of art that's not commonly understood. They're building out these legal principles that courts can then apply and flesh out. Yes, at this kind of medium-high level of establishing auxiliary legal principles, as Justice Kagan was explaining, but then also refining what those auxiliary principles actually mean on the ground. What does it mean for a death threat to be sufficiently menacing to qualify as persecution or not? And again, that is why the decisions in this case, like in so many others, are looking to these prior decisions to figure out what is the mode of analysis that is applicable to these facts. And if you go to many circuits, in fact, to help their staff attorneys and law clerks have these very detailed outlines explaining prior decisions that came before, so that it helps them assist their judges in making correct and efficient decisions that can be squared with the cases that came before them. But the irony in this context is that a lot of those decisions, the ones that are at least denying relief, they're not holding that the BIA's decision was correct as a matter of law. They're just saying that it was reasonable. So you have courts, you have the agency, they're all looking for guidance on this question. They're looking for precedent to use in making their determination, but they don't have a clean set of precedent to do that. They don't have precedent where courts have come in and said, this is in fact the correct interpretation of persecution as a matter of law. And that is really the problem here. And again, courts are already doing the kind of inquiry that we're suggesting here under the Convention Against Torture. In most courts of appeals, if the facts are undisputed and the sole remaining question is whether those facts demonstrate mistreatment rising to the level of torture within the meaning of CAT, they review that termination de novo, and they're doing just fine. And that's correct, because it builds out a body of precedent that courts can use effectively for future cases. And that is the kind of judicial work that under U.S. Bank we think would counsel in favor of de novo review, and it's the kind of judicial work that makes clear that this inquiry is not a finding of fact within the meaning of Section 1252B.